Good morning. So we've heard some good speeches here from both Barb and April, and my role in all of this is to actually crunch the numbers and come up with the final calculation of the economic damages. So just to give you a little bit of background about myself, I was born and raised in Spokane. I've got a bachelor's degree and a master's degree, both in economics, from the Pac-12 powerhouse, Washington State University. Every year as a Cougar fan, there's only so many wins potentially on that schedule. This year I was hoping maybe we could beat UW, but after watching the Huskies beat Southern Cal last night, it's time to get real here. So for the past 13 years, I've been doing economic damage calculations on a full-time basis, which basically means for the last 13 years I've had to explain to my family and friends what exactly it is I do for a living, because I'm convinced some of them still think I'm just making it up, the term forensic economist. So for 10 years I worked for a company called Harper Incorporated. Once my former boss retired at the end of 2012, I was able to take over the company and continue to do the same type of work that I've been doing again for the last 13 years. Over the course of my career, I've worked on over 800 cases involving pretty much every type of economic damage you can think of. In terms of volume, I mostly work on personal injury cases and employment cases. I also work on wrongful death cases, various business interruption cases, or business valuation cases. For example, I've got a case right now. It's a class action lawsuit against the Washington State Patrol, where they've never recognized veterans' preference points for their veterans for the past 65 years. And so currently that case is, I'm setting up a potential loss model that may involve several hundred current and former veterans employed with the Washington State Patrol. So again, nearly all the work that I do is in a litigation context. So any opinions or reports that I prepare, I fully expect those opinions to be criticized by opposing experts or cross-examination from the other attorney. About 50% of the time I'm retained by the plaintiff, 50% by the defense. So I've got a lot of insight of working with plaintiff and defense attorneys to kind of formulate, an effective model to present the damages and come up with the most favorable result possible. And again, I've testified primarily in eastern Washington and North Idaho, but I've also done cases throughout the state of Washington and Idaho as well. So this slide here talks about just, again, generally what the role of the economist is. Simply put, the economist is the one that's going to be providing the testimony to the final damage, which we say is stated at present value to the jury, or prepares a report summarizing what that final damage is. And any time that I prepare an actual damage conclusion or a range of loss calculations, I'm looking at two different scenarios. You're always looking at for example, a pre-injury forecast of what the plaintiff's expected wages and benefits would have been, but for termination or injury. And you're comparing that stream of income to what's expected to happen following the injury. So over the course of a case, I'll rely on, whether it's a vocational expert or if it's a life care plan, I'll rely on the opinions of other experts, or again, just use kind of generally accepted methods to come up with that loss calculation. Now you might be wondering, okay, anybody can simply multiply two numbers together. What takes a little more skill and experience and expertise is determining which two numbers to multiply. And so You know, there are different attributes that set maybe one economist apart from another in terms of how effective they end up coming across in their presentation. The first one, in whether it's an economist, vocational expert, or life care planner, you want your expert to come across as being as independent and objective as possible, which means, you know, the fewer assumptions that you ask your expert to make, typically the better. You want the expert to be able to independently verify those assumptions, make sure they're reasonable, and again, that's going to avoid a lot of cross-examination. If an economist does a calculation based solely on assumptions provided by the attorney, then the defense attorney will definitely attack that, and again, getting back to the 3Ds, try to discredit that entire opinion. The second item, an economic expert needs to be able to communicate in non-technical terms. When I testify to a jury, I understand that I've only got their attention span for so long. And if I'm just talking about a bunch of numbers, growth rates, loss dates, present value, net discount, terms like that, I know I'm going to lose them right away. So when I testify, I like to use some slide exhibits to kind of summarize all of the analysis that went into it. Juries tend to be able to track that a little easier, looking at a bar graph instead of me just rattling off a bunch of numbers. You know, and another important characteristic is extensive trial experience. Again, that gets back to just someone who's prepared for trial, someone that can think quick on their feet during cross-examination. You can always count on the opposing attorneys having one or two headshots that they're going to try to make to discredit you in front of that jury. So an economist that kind of anticipates what those questions are going to be is going to be much more effective. You also want an economist, or again, any expert, that has a good understanding of what are the generally accepted methods and data sources that are used. And not only that, but understand why those are generally accepted and why other methods are not generally accepted. In my profession, there's a number of journals, there's surveys of economists throughout the country. One of the more exciting journals, the Journal of Forensic Economics, surveys about 500 economists throughout the country, and they survey the methods that they use. So again, at trial or in my reports, I can reference that information to show that the methods I'm using are consistent with, say, 90% of economists throughout the country. So whether you're trying to use that for additional support, or if you have trouble sleeping, I suggest looking up, getting a subscription to the Journal of Forensic Economics. Another important attribute here is going to be just the ability to identify the key issues, you know, the strengths and the weaknesses of a case. And every case is going to have strengths and weaknesses. And you want the economist to really focus and drive down those key strengths to a jury or in their loss analysis, but at the same time be aware of what the weaknesses are and be ready to, again, handle critiques or cross-examination of those items. Being a critical and strategic thinker, another important attribute, and that gets to setting up an effective loss model. I see a lot of cases, especially if I'm retained by the defense. I'll get a loss claim presented by the plaintiff, might be a small business owner, and it's clear that either the plaintiff attorney or the plaintiff himself or herself, they don't know how to really effectively set up and show how they were damaged. And so from my perspective, when I'm on defense, I'm able to really exploit that they haven't really proven any sort of damage there. So again, critical, strategic thinker, you're able to come up with an effective loss model that's going to come across to a jury and get more effective results. And again, the final thing, ability to handle cross-examination, responding to opposing expert reports that critique everything you say. Again, it just gets back to understanding the accepted methods, having that supporting documentation in your file, to be able to defend those opinions. So I've got a couple of examples here. This is a slide that I used earlier this year at a trial. This was an employment case that I was working on behalf of the plaintiff. And in this particular case, the defense expert forecasted her future wages by simply averaging the years 2008 to 2011. And when you looked at her wages, you could see that those 4 years were much less than any other year she had ever worked. And so for my analysis, I did two things. Number one, I interviewed the plaintiff to get an understanding of why exactly her hours dropped during those years. I looked at the 8 years of her historical pay records to identify this chart here that shows her average number of hours she worked over this 8-year period. Again, she was terminated in 2012. But clearly you could see there was a big drop in hours there in 2008. So I clarified with the plaintiff, and she said that in 2008 her brother had been involved in a serious accident. She voluntarily went on a part-time status to become his full-time caregiver. And in 2011 he passed away. She returned to full-time status, and therefore her hours came back up in the year she was fired. And I was also able to verify that through her payroll records, finding the exact documents where she went on part-time status as opposed to returning to full-time status, and was able to explain that to the jury that using closer to a full-time rate was more reasonable for the next 10 years. The defense expert, again, simply looked at the 4 lowest years, didn't understand why exactly those years had dropped, and he took it a step further and assumed that because she was part-time, she would have lost all of her employer-paid fringe benefits, $500-600 a month in health insurance. And so he came up with a significantly lower loss, and again, not understanding why those hours declined and why those 4 years were not reasonable for the future projection. This is another example of showing a range of loss calculations. This is a medical malpractice case involving a cancer misdiagnosis. And one of the big unknowns in this case is the plaintiff's remaining life expectancy. It's unknown how many more years she's expected to live. So this particular chart that can then be used by the jury is to show, once the jury hears all of the medical evidence, testimony from the life care planner, both sides' testimony, they can use this chart to come up with an effective loss amount based on how many years that they determine is reasonable that she's going to live, whether it's anywhere from 1 to 10 additional years. So this chart shows, again, this involves a substantial life care plan for her ongoing cancer treatment. There's some past household chore services, future household chore services, and all of these are contingent on how many more years she's expected to live. For example, if she only lives 1 additional year, then her husband's going to sustain a much larger loss of future household chores, as well as some future lost income support. This plaintiff receives, she's retired, she's on a pension plan, and also receives Social Security. So her husband would lose some income support from those sources if she were to pass away much earlier than had this cancer been properly treated to begin with. So to hit on the key points here of, effectively using an economic damage expert, and I think this also goes towards using vocational experts, life care planners. In my experience, retaining the experts as early as possible can really add the most benefits to the case. So if you retain your economic damage expert early in the case, They can provide you early on with a preliminary estimate of what the damages are and help you identify the strengths and the weaknesses of your case. And knowing those items may change your entire strategy of how you want to pursue the case. The damages might be more than you expected. They might be much less. Kind of manage your client's expectations, that sort of thing. Again, identifying the most effective and defensible loss model. If you retain the expert earlier in the case, they can help you from the very beginning, identify key documents to request before discovery deadlines, provide you with some deposition questions, or whether or not it's worthwhile to depose other experts on the other side. And again, at the end of the day, you want your experts to be as prepared as possible to give their opinions at trial. And so if they're retained sooner, they have a chance to be the most fully prepared for presenting their damages. And getting back to the point here on coming up with the most effective damage model possible, I was speaking with Larry Beck last week on a case that I'm working on with him. We were talking about this conference today. And Larry mentioned that last year he did a presentation on the Dixon versus City of Coeur d'Alene case, which, if you're not familiar, that was a former police lieutenant that was wrongfully terminated. And the jury came back with a $3.7 million verdict, which included $2.7 million in economic damages. Well, in that case, which I testified on, as part of the damage and coming up with the most defensible model possible, when I was looking at possible retirement ages for Mr. Dixon, the first one I used was age 60, which is considered the full service retirement age for somebody in the PERSI pension system. And under that calculation, I came up with the $2.7 million in lost wages and benefits. But I also looked at, Idaho has, it's called a Rule of 80 retirement. So under that pension system, if your age plus years of service equal 80, you can retire with a full pension. So for Mr. Dixon, he was eligible for a very large pension, or would have been eligible at age 51. So I prepared a second calculation had he retired at 51, and given the size of the pension benefit, that loss was still $2.4 million. So I was able to present to the jury that a range of retirement dates from 51 to 60, yet the total difference in loss was only $300,000. And by doing that, I knew that it was going to be tough for the defense to cross-examine me, challenging me for using an age 60 retirement, when again I was showing, well, if he retired even at 51, which he was not going to think that was unreasonable, still produced $2.4 million. Ultimately, the jury decided that the age 60 was most reasonable and awarded that full $2.7 million. Now, cases where I'm working with a vocational expert, and primarily, in my experience, that's going to be cases that involve personal injuries, and where I would use, well, to get back to the main point here, I think the main point in my experience is that the economist and the vocational expert need to be on the same page. It's very important for them to have a discussion before reports are written. Open line of communication. You want them to avoid duplicate work product. You don't want to pay for a vocational expert and economist to do the same thing and find out that those opinions are different. So again, you want those opinions to be very consistent. Several times when I'm hired by the defense, one of my more effective critiques is showing how the plaintiff's experts are inconsistent with one another. They may both look at the past earnings and come up with a different pre-injury capacity, post-injury using different work-life expectancies. And that does not look good to a jury when you have two experts on the same team that are clearly not on the same page. So again, it's important for those experts to really, early on in the case, kind of define, here's the expertise, here's the benefits they can add to the case. Because ultimately at trial, you want the medical experts to testify, the vocational experts, life care planners, and then finally, usually the economist is last to kind of put it all together, and hopefully it's a nice consistent flow. So,
excuse me, what in your mind is the appropriate division of labor between a vocational expert and an economist on things like past what earnings would have been in the absence of the injury versus the future?
in terms of the past and future, kind of the difference between, say, an economist and what a vocational rehab expert can add. The majority of cases I work on, I will typically look at what the person has earned or demonstrated to earn in the past and do a forecast based on that projection of what they've done in the past. I will rely on the vocational expert, again, to review the medical data, really identify how the injury has now impacted that person going forward. Maybe the person can no longer do a previous career. What are the retraining options? Are they part-time, full-time? So the vocational rehab expert can really identify that post-injury capacity. And that's something that I would rely directly on from the vocational expert. But again, it's important for them to communicate early on. For example, just a few days ago, I had a case working with a vocational expert, again, another Idaho State employee. This vocational expert, obviously, he didn't know what I had already looked at. So by communicating with him, I was able to let him know that I have all of her past earnings information from the state. I've got a handle on all of her pension, health benefits, all of that information to make a forecast going forward. And that I really needed him to just pin down what, if anything, is she able to do going forward. So for his report, he was then able to just focus on that she is either not able to work or part-time limited, whatever the case may be, and then I can use that directly in my report for the mitigation analysis going forward. So
I think I have one question. So you would probably be the economic expert interview is the person who said, I want to know what the future earnings would have been in the absence of the injury. The vocational expert is not really necessarily that person. I mean, I see this redundancy a lot, and certainly even worse with the disagreement. But so I'm trying to get a sense of what you think is the right balance.
again, speaking out of my experience, I'm more comfortable doing the pre-injury analysis. There could be certain circumstances where the vocational expert can add value there as well that I would rely on. But for the most part, like with a state employee, I'm very familiar with their pay schedules and the historical pay and growth rates and putting a value on all those fringe benefits to make a forecast, determine a reasonable work life or retirement date. And again, relying more on the vocational expert, how did this injury impact their ability going forward?
How do you estimate the promotions and increased earnings over time of an employee that is in a position to get promotions?
Well, that's going to be, again, on a case-by-case basis, but you might look at the performance of other employees, the average tenure by position title for different, for example, in the Dixon case, I did a forecast that he would be promoted to captain. I looked at, his education versus the other lieutenants in the department at that time, the probability of an opening that was expected to be in the next couple of years because it was known that somebody was going to be retiring. So I presented an alternative where he would be promoted to captain within 3 years of his actual termination. And ultimately, the jury awarded the damages based on the scenario where he would be promoted to captain. But again, depending on the case, you're going to want to look at the person's individual history, their job performance, either before an injury or discrimination, termination, that sort of thing, and just kind of come up with the most supportable conclusion as possible for future promotions. Your final opinion, you want to make sure it makes sense. So those are the kind of things that I'm going to look at for determining a promotion. Does that answer the question? Okay. So finally, kind of the role of the economist when there's a case involving a life care plan. To very simplify April's points, after she does a very thorough analysis to prepare her report, the life care planner is going to identify the appropriate medical items that are going to be needed, support why those items are needed, the replacement rates, do they need a wheelchair every 5 years, 10 years, that sort of thing, the cost of those items in that initial year or the kind of per unit price. And so the economist, obviously not qualified to challenge any of those items in the life care plan, will then do a calculation, a kind of project them through the plaintiff's remaining life expectancy, again, come up with that single value. Here's the amount of money needed today, the present value amount that's going to replace all of those future damages. So between the lump sum plus a reasonable safe rate of interest, which we call the discount rate, but through that, we're going to project how much money today is needed to fund those particular losses. So the economist is going to forecast reasonable medical growth rates, again, come up with this discount or interest rate. An economist can also look at potential personal expense offsets. For example, if there's a case where the plaintiff requires nursing home care and the cost of that care is in the plan, then the economist should take into account that the person is going to be saving the cost of the regular shelter expense that an average male or female would experience in their life. So that should be deducted from, say, the cost of a nursing home that they're expected to be in for the rest of their life. Same with food offsets. If there's a nutritional supplement you should account for, here's what the typical male or female is going to spend on food in their lifetime. The final thing, collateral source considerations. If it's a medical malpractice case, the defense can introduce potential collateral source payments to offset those future costs. In recent years, with the Affordable Care Act, defense attorneys are big fans of the Obamacare because they want to say, yes, this person may need these future expenses. We're happy to pay the premium so they can just go get a private insurance plan, and we're going to assume the private insurance plan is going to pick the tab up for all of these future costs. So even though those future damages might be $5 million, we'll give you $80,000 to go buy a private insurance plan through the health exchange. Everybody's happy. But in reality, there are many problems with that assumption. An economist can look at specifically what items are actually covered through private insurance. Personal attendant care, typically one of the biggest dollar amount items in a life care plan, and that is not covered by any sort of a private insurance plan. Same with household chores, home modifications, number of surgeries and other items are going to be contingent on the insurance plan's approval of those items. Might be items, a limited number of therapies that they'll cover, that sort of thing. But an economist can look at that and determine if it's reasonable for the general assumption that private insurance is going to simply pick up the tab, reduce the loss by 98%. So, all right, thank you.